So in this work package, we examined the use by firms of registered community designs. So registered community designs are a way for firms and individuals to protect designs, by which is meant the appearance of products. And the protection can be provided against copying for up to 25 years. But it's a relatively new system, and not much is known about how firms and individuals use protection through design rights. And so we interviewed companies about their use of this legal instrument for design protection. Countries across Europe have had different histories in terms of providing protection for designs. But over the last 20 years or so, it's been harmonized by the European Commission. So there is now a single system across Europe. Although you can register designs nationally, Germany, France, UK, Denmark, etc., there's also a European system whereby you can register with the European Intellectual Property Office and obtain protection for up to 25 years. So it's important because actually very little is known about how this form of intellectual property protection is used, whether it's effective, whether it's abused, and other questions such as this. We find a variety of different experiences. So in the UK, firms tend to not to register many designs. So there seem to be two main reasons for this. One reason is that there's not a widespread understanding of the system. So in general, there's a kind of ignorance that there is design protection available. But amongst those companies who are aware of design protection, there tends to be more skepticism as to its validity. So on the one hand, you can obtain design protection by paying a fee, €350 for a single design, rising to much higher prices for multiple designs. But the question really is how worthwhile that is. And often British firms feel that it's one thing to obtain protection, it's another thing to enforce it. So taking enforcement actions through the courts, for example, tends to be very expensive. And so firms tend to think that the value of holding design rights is more questionable to the benefit. In Germany, we found some quite different experiences. Now, on the one side, we found that in the car industry and the tool-making industry, firms tended to use this form of protection as it was intended. They would find their more innovative and distinctive designs and they would register them. So in a fairly small numbers of designs tend to be registered. In contrast, in another industry, in the footwear industry, we found that firms would sometimes abuse the system. So in order to register a design, it's supposed to be new and have individual character. Instead, we found that in some footwear companies were tending to just register everything. They just threw all of the designs into the registration system, whether or not they were new and had distinctive character. Possibly this is because it takes too long to go through the catalogue and decide which are new and which are have individual character. But it could also be to try to confuse competition, to distort the market somewhat, and to, for example, intimidate retailers as to taking these designs as opposed to designs from competitors. So the first implication is that it's important that designers and companies that produce designs are aware of this system and have easy access to it and know what it is required in order to register their designs. The second implication is that the balance between the simplicity of the system and its accessibility to designers who are often individuals or based in small firms is balanced against the sort of legal side, the legal complexity of the design system. Now, it does seem that what was intended as a fairly simple system is becoming somewhat legalized. Recently, there was a case which got to the Supreme Court in the United Kingdom in which, for sort of technical reasons, the design that was registered was found not to have been infringed. This was partly because the owner of the design had not submitted simple line drawings and had instead submitted more complex CAD pictures. But it meant that the design that he was seeking to protect was interpreted much more narrowly, and this essentially meant that it was not infringed by a company which didn't quite copy the design but did something rather similar. So it's important that we get the balance right between does it favor designers or does it favor those who might seek to infringe designs. The third aspect is the possible abuse of the system. Now, it's not helpful if people and companies are registering lots of designs which shouldn't actually be there. Because what you should do before registering a design is go through what's called the prior art, which means that you should essentially go through the database and see to what extent your design is new and has individual character. Now, if other people have registered all sorts of designs which are not new and do not have individual character, then it's going to take you a lot longer to go through the system and to see what are the prior designs than it would if people had used the system correctly. So there's an issue about how to drive out this abusive behavior which arises because designs are registered and not inspected when they're registered. So perhaps there could be a system of fines for those who are discovered to have abused the system.